Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
The trial court, after analyzing the statement made by the prosecution witnesses, wide judgment and order dated 4/4/2008, held the appellant guilty of offence under section 302 IPC and sentenced him to imprisonment for life. Stop. Being aggrieved, the appellant filed criminal appeal number 811 of 2008 before the High Court, challenging the trial court's order of conviction and sentencing. Wide judgment and order dated 22/6/2012, the High Court confirmed the judgment of the trial court and observed that there is no iota of doubt in the case of the prosecution, and therefore the prosecution has discharged its burden in proving the guilt of the accused for the offence under section 302 IPC beyond a reasonable doubt. Stop. We have heard Mr. Ravindra S. Learned Counsel appearing for the appellant and Mr. Mahfouz Learned Counsel appearing for the state. Stop. Mr. Ravindra Learned Counsel appearing for the appellant vehemently submitted that the weapon knife alleged to have been used by the appellant in the commission of the offence was not seized by the police, and non-seizure of the said weapon is fatal to the case of the prosecution. Stop. It was further submitted that the prosecution failed to examine the scribe of the FIR and that there was a delay in sending the FIR to the court. Stop. It was further submitted that the presence of eyewitnesses in the place of occurrence is very doubtful and incredible in the circumstances, and becomes further incredible as none of the so-called eyewitnesses is even able to describe the weapon of the offence, despite the prosecution case being that the appellant was apprehended by the crowd, but still he managed to run away. Stop. It was further submitted that the inquest report clearly shows that the alleged eyewitnesses merely expressed their doubt with respect to the appellant that due to previous enmity the appellant might have killed the victim, and this shows they only had a suspicion and were not witnesses to the incident. Stop. It was further submitted that the falsity of the prosecution case and the theory of the appellant running away in the backdrop of his receiving treatment for such serious injury in his leg that he had become invalid for doing labor work and was receiving treatment for the immediately preceding last 6 months, further makes the case against the appellant extremely doubtful. Stop. Per contra, Mr. Mahfouz, learned counsel for the respondent state, has duly supported the conviction and sentencing of the appellant with reference to the material on record, and as regards the conviction of the appellant, it was submitted that the judgment passed by the trial court and the High Court, after thorough appreciation of the evidence, does not suffer from any infirmity and call for no interference, stop. There are no grounds made for reversal of the conviction, stop.